everything?
Doing well, doing
Good.
well.
Good.
Was in the Keys this past weekend and
Stolen one thing.
Yeah, I was surprised my son's going to college down in West Palm Beach.
I'm not talking about the criminal.
Oh, no, I know.
Where's she going?
Yeah,
Palm
especially
Beach Atlantic.
Venezuela, will then
Yeah.
be killed if they stay
And
home in some
It's,
places.
you think it's just a small little city, but it's not. There's just not a stop anymore. It's
When I was there,
there's no gap between
it
the
was
cities.
very, very progressive.
Irish has
There may be some
There
wisdom.
were two malls. One was the Dayland Mall,
Just tell them before you got here.
and then there was
This was
one
my 30th year.
the only
They were
malls
just
here.
leasing those, they didn't belong to the.
Sports teams, of course, spring training.
There's
There's
not
a lot
like
of
a
money.
dentist office over there.
91
And I know there's a neurologist
It's a very
Take the kiss.
office
Can't beat a kiss.
When I got married and moved there for a while, my wife worked at the newspaper.
I would think
She did advertising, and she was down the lobby one time, and lady was asking us, she just ragged her, she loved the place. And the newspaper's nice little newspaper. And she says, what do you think? I'm gonna ask you another question. I'm having a party Friday night. She said, it'd be great, thank you. And she said, would you like to come? She said, yeah. She come down there and she went upstairs, she said, I invited you to a party. I said, where? She said, well, here, please. It's Merriweather Post. She said, that's the daughter of the post-serial guy. He bought the newspaper for her as a plaything. So we went out to the house. We went in a house. Illinois and Donaldson Stores. These big places. And we went, that's where her house was. One of those. And they park your car for you. Took us in, introduced us, all kind of good things. Well, she got it.
You're preaching to
They
the
sold the
choir.
house. Some rich guy came in and bought it. The name of the house was
Hey, Joy.
The word inane.
I got
You can insert
I got
joy.
dinner at Mar-a-Lago.
Because we're the MPO team, Metropolitan Planning Organization, but we need to get the meeting started, it's 9:30.
I did.
Thank you.
I just drove around just to,
I'm from originally.
I'm from Michigan.
That's where Nancy's from. The Irish Hills area.
What were you saying?
I've been down there. So,
My folks came,
gonna feel nice.
I think my father said he was 7 when they came down. Something like that, real young. But, he used to be a caddy for Babe Ruth. They get out of high school at 12 o'clock, and they go to the country club, caddy. And, it's like these working class programs now. And, but he has to caddy for Babe Ruth at the end of the year, spring training.
No, it's over. It's over. It's wrong.
I was just looking at it, I'm like, I don't recall them having shared.
So they
No.
hired him to drive his car to the military.
I've mentioned it a time.
I had some pictures of my father and my brother. I think so. I don't know where it went.
Hey, everyone, it's 9:30, 9:31 now. Thank you for attending the meeting. It's actually 9:32, so we're gonna get this started. Mr. Brown actually brought it to our attention this morning. This is his 30th year on the transportation, so thank you very much for your, thank you very much. Mr. Douglas, we can call this meeting to order.
Yes, sir. Let's do with a moment of silence, please. Thank you. And Pledge of Allegiance.
I pledge allegiance.
Introductions of board members. I'm Dave Douglas, I'm vice chair, and I'm the citizen transit advocate. Steve?
Stephen Brown, and for the visually impaired
Bud Osborne, representing the veterans.
Dave Newell, in for Tracy Noyes for FDOT.
Deirdre LaBelle, representing Children at Risk.
Joanne Granger, Citrus County Transit Director.
Karen Brunk, Department of Elder Affairs.
Katie Lucas, Medical Community Representative.
Joy.
Joy Turner, MPO Staff.
Mary Elwin, MPO Coordinator with the MPO.
Bob Esposito, MPO Staff.
Is that better?
And do we have a quorum?
Yes, we do have quorum.
Thank you, ma'am.
We have somebody presenting, so they're gonna need to be presenting there.
I'm sorry.
No, you're fine.
Please enter the proof of publication into the record.
The notice of this meeting was published, and that's all, yeah.
Thank you, ma'am. Are there any changes to, or additions to the agenda?
No, sir?
I need a motion to approve the agenda.
So move, Katie Lucas.
Second, Stephen Brown.
All those in favor?
Aye.
Opposed? Passes. Presentations.
Thank you. Our first presentation is Government in the Sunshine and Conflict of Interest presentation by the Hernando County Sheriff's Office and the President.
Attorney's Office. Hernando County
Did
Attorney's
I
Office.
say sheriff? Sorry.
It's okay.
Attorney's Office.
I didn't want to scare anybody.
They both scare me. We have Victoria Hill actually giving the presentation from the Attorney's Office.
Good morning. I'm fine. Okay. Okay, and it's fine, because the changes I made, they were like a couple of errors, and I moved the slides, I'll just skip over the slide. Yep, yep, that's fine. Perfect. All right. Okay, all right. Good morning. My name is Victoria Anderson. I'm the Assistant County Attorney with Hernando County Attorney's Office. And I'm going to cover just briefly sunshine the law, public records, and in a little more detail, again, I guess I have a 10, 15-minute time limit, voting conflicts. I did prepare in advance. I'm not certain if they, okay, have a copy of it, and I'll get to that at the end, the handout that was given to you. But I'll start now with the sunshine and the law overview. I'm sorry, I'm operating two different things here. So Section 286.011 of the Florida statute provides right to access to governmental proceedings, and this is for proceedings of public boards or commissions at both state and local levels. There are three basic requirements: that the meetings must be open, reasonable notice, and that the minutes of the meetings are recorded and then open to the public for inspection. The Sunshine Law applies to any meeting between two or more board members, ad hoc meetings created by public entities, corporations, or private organizations delegated authority to perform on governmental functions, and when discussing matters that may foreseeably come before the board. There is a limited exception. Committees created merely for the purpose of fact-finding, the Sunshine Law does not apply. The meeting includes any county commission meetings, telephone calls, text messages, emails, other written correspondence. Staff meetings generally are not subject to the Sunshine Law. However, a board member cannot direct staff to circulate information that is that's before the board to another board member for the purpose of sending information. The Sunshine Law applies to formal and informal functions as well, and there does not need to be a quorum for the Sunshine Law to apply, because again, it's about information being circulated. You can attend social events as long as you don't discuss issues that may foreseeably come before the board. The Sunshine Law does not apply. There is a limited exception. I do apologize, that's kind of bright there. A written report may be circulated prior to a meeting, but no comments or discussions may be had until publicly noticed, and that's pursuant to an Attorney General's opinion, 8923. I know that's kind of light, but if you want to review that opinion, that's Attorney General opinion 8923. Public records law. This is pursuant to section 119.07 of the Florida statutes. The Public Records Act is construed in favor of openness, and while exemptions are construed pretty narrowly and limited. Every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at a reasonable time and under reasonable conditions, supervised by the custodian of the record. The agency can charge a reasonable fee, and the person requesting the records request does not have to explain the purpose behind that request. Section 119.01, subsection 12 of the Florida statutes, a record is a public record if it's made or received pursuant to a law or ordinance, or it's made or received in connection with the transaction or official business of the agency. There is a case that further defines this by the Supreme Court, Chevron versus Byron, where the Supreme Court states further defines public records as those that are intended to perpetuate, communicate, or formalize knowledge. So any document that's intended to perpetuate, communicate, or formalize knowledge of the board is considered a public record. So what types of documents are public records? According to the statute, that includes all papers, letters, maps, books, tapes, materials, regardless of the physical form or characteristic or means of transmission pursuant to law or ordinance in connection with a transaction or official business. So regardless of the location of the record, that doesn't determine whether or not it's a public record. The record does not need to be located on a county or government server to be considered a public record. For example, if you use your personal email or your personal cell phone to communicate official business, then those documents or those things that were communicated would be considered a public record. The Attorney General has advised in an opinion that if the agency puts their material on Facebook or social media such as Twitter, that will be presumably connected to official business and be considered public record. There are some exemptions, statutory exemptions. I'm only going to cover a few, and this is not an exhaustive list, and this is just strictly from 119. Which would be Social Security, bank account numbers, security information. I know that's more of a recent update, specifically security information and plans in reference to things such as your security of your building or your certain systems or computer systems. That is exempt from public records. Bid information for a limited time only, and attorney work product only until litigation is complete. After litigation is complete, those documents are also open to public records. There are some exclusions, personal notes and drafts for personal use of the writer. So if you're jotting down notes for your personal edification, that is excluded. If the personal note or draft, however, makes it into a county file or in whatever document or filing system you may have, it becomes public record. If the personal note is drafted or added to anything that is the actual thing that you're deciding on becomes public record. And just a couple of extra things, if you receive a request for a public record, you must state what the actual exemption is, so you have to note the actual statutory number and why you believe that it's exempt. A brief explanation on why you believe it's exempt. The burden is on the agency to document and state why you believe the public record is exempt. Public records are only records that have been created. So if somebody makes a public records request and the record doesn't exist, the record doesn't exist. You don't have to create a record. You don't have to jot down memos and notes about the record or what you did to look for it. If you create anything in reference to a document that doesn't exist, it actually becomes public record. So you don't have to create anything. And there's also no particular time frame. There's not a 24-hour window or a 10-day window. The Supreme Court, I believe, in a case, and I don't have actually case notation, says it has to be a reasonable time, and that's just is exactly what it is. Sometimes the records requests are voluminous, so the time frame to actually perform it and produce those records takes more time. And actually, that is one of the slides that I intended to remove, so I'm going to skip over that one. And we're going to spend just a little more time in the voting conflicts. Section 286.012 of the Florida statute requires specific officers to vote except when there is or appears to be a possible conflict of interest. The Code of Ethics for public officers and employees is found in Chapter 112 of the Florida statute. And I'm only going to cover 112.3143, which is voter conflicts, but 112 includes outlines regarding basic principles of conflicts, the fact that local governments can make and enact more stringent standards, and actual conduct for public officers. In 1975, the Code of Ethics was passed, and it addresses standards of conduct for voting, conflicts of interest, and for financial disclosures. This applies to county commissioners, board-appointed committees, and board employees. It prohibits certain actions and conducts, and again, it requires certain disclosures based on certain actions or conduct. Section 112.3143 requires no county, municipal, or local public officer, including members of board-appointed committees, shall vote in an official capacity upon any measure which would inure to the special private gain or loss of themselves, any principal or entity by whom they are retained, other than the agency, which is defined in 112, or to any relative or business associate. So to whom does this apply? This applies to public officers, that is persons elected or appointed to hold office in an agency, including persons serving on an advisory board. So essentially, if you're a member of a collegial body or a body at the state or local level, it applies to you. So the voting conflict rule. The voting conflict rule is for local elected or appointed officers, which means a local elected or appointed officer may not vote on any measure that would inure or result in his or her special private gain or loss. It applies regardless whether or not the local officer realizes at the time of the vote that the effect of the vote will have, or any measure which a public officer knows would inure to a special private gain or loss of principal, parent, relative, or associate business. So both of those, the one where the elected or appointed officer inures a special private gain, or knows or should know would inure a special private gain of a principal, parent, or relative, both triggers the voting conflict memo. So is the private gain or loss either to yourself or private gain or loss to a principal, relative, or business? Either one of those two would trigger the Form 8B. So the key to kind of understanding when you would actually do the form is understanding a few definitions, and that would be the principal, relative, business associate, and what is private, special private gain or loss. So private gain or loss requires an economic benefit or harm that would inure to the officer, his or her relative, business associate, or principal. So principal, again, it is an employer, but it's an immediate employer, a professional type practice, which includes its employer and its clients. So it's not just employer, it also includes clients. So for example, a law office, it would include the clients of the law office. Even if it's pro bono. For a corporation, compensation is key. And if there is no pay, then there may not be, that person may not be considered retained for the purpose of business. So that's the key for determining whether or not, if you're on a corporation, if you're compensated, then that would be a principle. Relationships such as memberships in churches, landlord-tenant, homeowners associations, campaign contributions, those things wouldn't be considered principal relationships. Relative, that definition is different than the similar definition of relative in the anti-nepotism and gift law statutes. For example, a boyfriend of a relative under this particular provision, the commissioner says you look at the reality of the circumstance. So if a boyfriend is living with a relative and they're sharing expenses and they're purchasing and they're sharing losses and gains of certain investments and banking accounts, then that actual household member would actually constitute a relative for the voting conflict purposes. If that relative actually had a principal or an employer, that probably would not reach as far when you're talking about the employer of the relative. I'm sorry, the employer of the boyfriend of the relative. It kind of gets a little convoluted there. Just probably wouldn't be enough. It's fact specific. I think when it gets that nitty gritty, those are the times you actually go to before a board, or not go before the board, submit questions to the commission or to county attorney's office to get some direction on that. Business associates. Businesses are they engaging in a common commercial or entrepreneurial pursuit, or is this a current ongoing business relationship? Is a business associate relationship, the shareholder is it private stock or is it public stock? Those are the things that determine whether or not you have it's a business associate. So understanding the little nuances of principal, relative, and businesses. If it is a principal, relative, and business and there is special gain or loss, then that would trigger the memo. Special private gain or loss private gain or loss does not apply to all situations. The gain or loss has to be special. It requires an economic benefit or harm that will inure to the officer, again, his or her relatives, business associates, or the principal. To be classified as special gain or loss, there has to be some economic effect resulting from the vote. The class size, so what size is a class? The larger the size of the class, the less likely there is for loss or gain, for it to be special. The smaller the class size, the more likely it is for there to be special loss or gain. So there's an example. Let's say that Busch Gardens has decided to come to Citrus County and actually have a new, theme park here, and extend their theme park to Citrus County. And there are some rezoning requirements that are needed. A lot of matters are before the Planning and Zoning Commission, and one of the board members has property that's adjacent to the actual property that's going to be zoned for Busch Gardens. That would probably be considered a special gain or loss because that would somehow impact the property value, or could impact the property value of that one board member's property. That class size of 1, he's the only person, creates a special gain or loss. If you take that same fact pattern and say there's a neighborhood of 200 property owners and that one board member is one of the 200, that increases the number, makes the class size larger, less likely that there is probably not special gain or loss because he's only 1 or 2% of the actual group of people. And I believe that there are some opinions in the commission where they talk about percentage. There is no hard rule or number, but the lower, and I'm talking about the lower the percentages, is less likely there is special gain or loss. The higher the percentages, the more likely it is special gain or loss. Is the gain or loss remote or speculative? The degree to which there is uncertainty at the time of the vote as to whether or not there would be an economic benefit or harm to the public officer, his relative or business associate or principal, and is the nature or degree of that economic benefit or harm must be considered. So this comes into play if it is highly uncertain at the time of a vote whether a voting office will experience gain or loss. If the possibility of economic effect is so remote or so speculative, then no special gain or loss will most likely be found. Is this merely preliminary or procedural? So whether or not you look at the nature or the interest that's before the vote. So if, for example, you have a vote before you and it is to delay or to expedite a vote on some other substantive issue, that is preliminary or procedural. So if a board member has an interest in the thing that's substantive, they can actually vote on it if it's just merely preliminary or procedural. But that can be a little tricky too. For example, I believe there's a case, and that would be one that you definitely could go and read. It's Ethics Opinion 9310, where Town Council of Town Orange Park was determined that he had a voting conflict from voting on the matter of a survey. Although the survey was not the substantive issue, it was a preliminary or procedural issue. If he voted on that issue, the survey would be the thing that would be a key thing in the substantive issue. So if he had a hand in voting in something like that, although on its face is preliminary and is procedural, it could be it could affect some substantive nature. So you have to make a determination whether or not it's merely, and it has to be merely procedural preliminary. It cannot have any effect on the substantive vote. So reviewing those things, and again, helps you determine whether or not you're actually going to complete the Form 8B. So if you have a voting conflict, what do? Local elected or appointed officers must abstain from voting, disclose conflict orally prior to the vote, and file a memorandum within 15 days. The form does split in two parts, separate instructions for local elected officers versus the appointed officers. Again, the local elected officers have to do the abstain from voting, disclose conflict, and file a memorandum. If the person is an appointed officer, in addition to the three above, the appointed officer must disclose publicly conflict before participating in the discussion. So they can participate in the discussion, but they must disclose the conflict. If they do it orally, they still have to go back and file the Form B within the 15-day time frame. Such disclosures shall be made by memorandum. They also must be filed in public record with the clerk, which shall be immediately provided to other members and which shall be read at the next official meeting, and this is pursuant to Section 112.3143 of the Florida statute, subsection 4. So if you have more than one conflict, you have to actually enumerate each conflict on the Form B. You can always say see attached and list every conflict that you have on the actual form. The next one really doesn't apply. Well, I guess it could. When a conflict arises related to a client of legal practice, you must disclose the nature of the conflict in such a way as to not to infringe on client-attorney relationship. So meaning that, of course, don't disclose if there is anybody practicing, don't disclose anything that would infringe upon that relationship. It just needs to be enough to give public notice about what the conflict is. The voting conflict statute does not require you to leave the room, but again, local government can have their own ordinances and policies that can be more stringent. So if there's a policy that you leave the room during the discussion or during the vote, then you adhere to that policy. It's just not required by statute. So there are some exceptions. If the principal by whom you are retained is a public agency, you may vote. That's one of the exceptions. If you're a commissioner of a community redevelopment agency, RDA, or CRA, or a 1 acre, 1 vote officer, you may vote. If the measure affects your expenses and compensation provided by law, you may vote. And again, there's a handout that you have, and it's strictly voter conflict ethics attorney opinions. I'll put a big, huge disclaimer on that. It is the question and the summary without the facts. And I think you guys know that every one of those cases is fact specific. So I encourage you, it's just meant to be a little cheat sheet to help you maybe locate if you're thinking, this may be a voting conflict. And it gives you the question and the answer, but then you should go and read the actual attorney ethics opinion on the facts, because little things, little nuances of the facts determines whether or not this answer is an answer that you can use and say, okay, yeah, this is not or is a voting conflict. And that is not an exhaustive list. That would have been probably a ream of paper. And that was just voting conflicts. That's not any other conflicts that are recorded on the commission. It's strictly for voting conflicts, but I thought it would be a nice little thing to have to browse through, because it really covers a lot of questions that you may have that are just like routine questions, things that have come up from the 70s on to 2023. Every one of those opinions you can find. The only downside is when you go, and I'm certain you guys have been on there, it just has years. There's no way to search, keyword search, so you almost are going in and clicking blind to see. I guess I probably could have provided a Word document of it, because you can always just add to that as you find something, and keep that as just, again, your cheat sheet. So I believe the key to actually determining whether or not you have a voting conflict or whether or not you need to have that form filled out, it's not only an understanding definition, but also being familiar with some of the ethics opinions where they've already answered some of these questions or a lot of these questions before. If you have any questions, my presentation, all the information that I obtained, I either got it from the Florida Attorney General's website, from the Sunshine Law Manual, this 2023 version, or the Florida Commission on Ethics, the website, and there's an ethics manual there that is a wealth of information as well. So that concludes my presentation.
Thank you.
Thank you
Thank you. Thank you, Victoria. Are there any questions?
I would like to comment, thank you as a fellow lawyer. That is the best presentation on voting conflicts I have ever heard. And thank you for putting this document for us together. I know that had to take a lot of work. And this is like a CLE for me, so thank you very much. I was reading through it and I was like, I'm gonna take this back to my office and digest it, and appreciate also the review on public records. I don't think we can have enough reminders on that, so thank you very much. I always like to say, if it looks, smells, or feels like a conflict, ask your attorney, whoever that might be.
Good rule of thumb.
Yes.
Thank you.
Thank you. Excellent presentation.
Anyone else? Thank you.
Thank you.
It's 10 o'clock, so we can actually move this to the next agenda so that they can close the public workshop, or continue with the public workshop.
Let's just continue and just finish this out and do the next one.
Then
So.
go ahead and announce that, because anybody here for 10 o'clock needs to be aware.
Okay, our public workshop's running a little bit long, so we're just gonna continue it and hopefully wrap it up quickly before we get on to the regular meeting that's supposed to start at 10 o'clock. The next thing we have to do is the Transportation Disadvantaged Local Coordinating Board Orientation Overview, which Mary's gonna go over for us. Thank you.
Again, good morning, everyone. So the purpose of this is just to give an overview of what the Transportation Disadvantaged Local Coordinating Board program is all about. A lot of you are familiar. Mr. Brown is aware, 30 years, he's got it, he knows it, he can probably recite it, but as part of our grant processes and as part of our education and learning efforts to make sure people understand what is going on and what services are out there, this is why we're doing this. So as soon as she gets that loaded.
The mouse has a mind of its own right now, my apologies.
Ain't no pieces to pieces.
So I will work as fast as I can, but please know that if you have questions or comments or anything, please let me know. The purpose of the Transportation Disadvantaged Local Coordinating Board, and I'll call this one Local Coordinating Board, or LCB for short, so I don't have to keep doing that, is to identify local service needs and to provide information, advice, and direction to our Community Transportation Coordinator, who in Citrus County is Citrus County Board of County Commissioners, is your Community Transportation Coordinator. In Hernando County, it's the Mid-Florida Community Services, doing business as Trans Hernando. So, I'm sorry it's kind of light, but the coordinated system was established in 1979. The legislature created the Commission for the TD, Commission for the Transportation Disadvantaged, and TD Trust Fund the same year. The purpose was to deliver coordination of transportation services in each county. It was implemented by 3 primary entities at the local level. That's the Community Transportation Coordinator, also known as the CTC, if I say that, the Designated Official Planning Agency, and for that organization, that is the Hernando Citrus Metropolitan Planning Organization Board. And then the Local Coordinating Board for the Transportation Disadvantaged, which is this body. The Commission for the Transportation Disadvantaged works with its state and local partners, and the FDOT has a big role in that. The Florida Department of Transportation has a big role in that, to also purchase trips through a coordinated system. Trips can include bus passes, scheduled door-to-door paratransit, or on-demand services. Some of you utilize those services, and we're appreciative of that, and you give us good feedback on those services, and we appreciate that. Riders can be anyone. Somebody who's transportation disadvantaged can be an older adult, a person with a disability, persons with low income, they can't afford automobile, children who are at risk, and people who do not drive for one reason or another. Maybe they have a driver's license issue, or they have lost their license because they cannot see well enough. And they need transportation for medical services, job or work-related issues, school or college, groceries, medicine or personal items, social and recreational activities. And may have limited transportation options available to them in their community, such as they don't have the personal vehicle, they have limitations to getting to public transit, they have government-sponsored transportation such as Medicaid, there's private on-demand services, taxi, Uber, or Lyft, and some do not drive or have a driver's license, as I mentioned. So the Commission for Transportation Disadvantaged has a lot of responsibilities. They are an interdependent agency administratively housed in Florida Department of Transportation with a board that's appointed by the governor. So the administration of the TD Trust Fund and disbursements of funds happen through various grant programs. So grant programs mean you have to apply and you have to be eligible to receive those funding mechanisms. They develop policies and procedures governing the coordinated transportation system. They approve the appointment of community transportation coordinators. They appoint designated official planning agencies to help implement program. Again, that's the Hernando Citrus MPO board. And in Hernando and Citrus counties, the DOPA, of course, is the board. There are governing documents. There always are laws that cover, as you well learned, there are laws that govern everything that we do, and this is covered under Chapter 427 of Florida statutes and Rule 41-2 of the Florida Administrative Code. So grant programs they offer are the trip and equipment grants, planning grants, the Shirley Conroy grant, and the Innovative and Service Development grant. These grants have different requirements associated with them. Some of them are competitive. The planning grant is administered through our MPO staff. The Shirley Conroy, the trip and equipment, and the innovation and service development are generally obtained by the CTCs, and they are used in their business practices. the CTC has a lot of responsibilities as well. They plan, administer, and monitor, coordinate, arrange, and deliver, and wash the dishes for the coordinated transportation disadvantaged. They do it all. And your CTC for Citrus County has done a very good job. They've received good evaluations. They coordinate with the MPOs and the DOPAs and the LCBs, which the DOPA is Designated Official Planning Agency, on the Transportation Disadvantaged Service Plan. That's the big, thick plan the board usually adopts and annually reviews every year, and provides the scheme, structure, and discussion of how they deliver service. And the CTC recommends eligibility guidelines and trip prioritization to the local coordinating board, and that's discussed and also addressed in your TDSP, your Transportation Disadvantaged Service Plan. A CTC can be a public transit system, a nonprofit, a private transportation company, or a local government entity, which in Citrus County, it's the local government entity. It's your Board of County Commissioners for Citrus County. And it can deliver services directly or sole source or contract with an entity to deliver those services. And then the MPO, which is Metropolitan Planning Organization, has a lot of responsibilities as well. The MPO assists CTC and the LCB to implement the local transportation disadvantaged programs. The MPO board appoints members to the LCB. There are quarterly meetings conducted such as this and an annual public workshop. There are recommendations to the commission on a community transportation coordinator, and actually during we actually assist in the competitive procurement process for getting a CTC in place. And then there are memorandums of agreements that are conducted and signed and executed, and then that process is instituted every 5 years. Also, the MPO helps to evaluate the CTC. There's a prescribed method of evaluating them. A huge document is completed and their services are reviewed, everything from A to Z. And the MPO works with the CTC to develop the TDSP, which is every 5 years, and then annually updated every year after that. The MPO reviews the annual operating report, and which is prepared by the CTC, and the CTC also does the annual expenditure report. It has to identify all their expenditures and how they use them. So there are a lot of MPO grant activities, the annual public workshop, which is what we're doing right this minute. We have the LCB bylaws reviewed annually and updated. All organizations more efficiently run if they have a set of bylaws, understanding how their meetings will be conducted, and that's the purpose of the bylaws. We annually review and approve the grievance policy, which is on your docket today in your regular meeting. And we do a CTC evaluation, as we said, and we develop the TDSP, and under a memorandum of agreement every 5 years, we function, and the annual operating report I already covered, the annual expenditure report. We provide and support technical assistance to the LCB. There are questions that come up from the community. We generally handle them. Okay. Excuse me for that. We review grant applications, coordination contracts, and quarterly reports, and any other activity necessary to implement the TD program. And then we attend and participate the meetings, seminars, training, and workshops sponsored by the CTD and the FDOT. And we utilize the MPO website to provide a way for people to get information about your transportation disadvantaged services. And then the local coordinating board, that's y'all, has a lot of responsibilities because you're serving as the local advisory body to the commission for the transportation disadvantaged. You assist with the establishing eligibility guidelines and trip priorities through your Transportation Disadvantaged Service Plan. You evaluate and perform the performance of the CTC annually. MPO staff helps to prepare that. You all review it and approve it. We review the rate models. You identify and prioritize local service needs. You review strategies of service provision in the area, evaluate multi-county or regional transportation opportunities. You meet at least quarterly and provide guidance on local coordination of transportation services. You appoint a vice chair, which you will be doing at your next regular meeting, which follows this meeting. You review and adopt bylaws annually and establish and annually update grievance procedures, which you'll be doing. And you appoint a grievance committee annually. Review and recommend other funding applications available under the TD program. It's quite a laundry list of responsibilities. And the members include local officials who serves as the chair. So I just want to make a note for the record and interject at this time that Ruthie Schleybaugh sends her apologies that she has not been able to attend the meetings in the last couple months, but she is hopeful to, but she is very appreciative of Mr. Douglas stepping up and chairing the meetings for her. So we wish her well. LCB members include include purchasing agencies from FDOT, could a local education community, vocation rehab, blind services, a veterans service office. Usually it's the officer for the county. Florida Association for Community Actions, riders, that means citizens that are persons that have disabilities, seniors, persons with low income, any of those meeting the requirements or eligibility to get TD service. Transportation provider organizations, medical community, workforce development board, and board membership represents local stakeholders and is appointed by planning agency. So there's our roster of our current membership, and we are grateful that you all want to be a part of this. Some of you are signed by your agencies, but we're still grateful for that, and we appreciate your service to your community. It's very important, and it's what we're here for. So are there any questions that anyone has over what the TDLCB does? Okay. So that is it. There's a bunch of reference information in your available to you, the different chapters, the rules, the bylaws, who, what, when, where, why. It's all available to you. If you ever have a question, please give us a call. We'll be glad to talk to you. That's it.
Thank you, Mary. Appreciate that. Mr. Douglas, we're on to citizens' comments.
Yes, sir. Are there any citizens' comments at this time? Seeing none, we move on to section E.
Right.
Board members' comments.
I think we're all good at this point.
Okay.
Excellent
Section
presentation.
F, MPO staff comments.
I'm
Are
good
there
for
any
the moment.
updates to discuss?
No staff comments,
No
sir.
staff comments.
Thank you.
You're welcome.
I now adjourn this meeting, and that is at, let's see what,
10:17.
10:17.
Yep. 10:17.
Thank you.
This meeting is adjourned.